question. Just to give you a brief background, this plenary session focuses on the strategies of jail decongestion release of PDLs and the current policies of the agency. We have 4 resource speakers, and before that, may we request the 4 resource speakers please occupy the seats on the stage. We have 4 resource speakers. Undersecretary Raul Vasquez of the Department of Justice will discuss with us bail and executive clemency and others. We have also our Undersecretary of DOJ, Attorney Dio Marco. He will discuss on the regional rehabilitation projects. Third resource speaker is Jail Director Raul Rivera of the BJMP, Bureau of Jail Management and Penology. And also our 4th resource speaker is Director General Gregorio Katapang of the BuCor. Let's give a round of applause for our first resource speaker, Undersecretary Raul Vasquez of the DOJ, Department of Justice.
Good afternoon, ladies and gentlemen. This is the worst time to talk because it's siesta time. But we hope that we would be able to gain your attention and focus so that we can discuss this matter of utmost importance. Before I start on my discussion of the output programs in respect to the jail decongestion efforts of the government, let me backtrack a bit. I've discussed this earlier with Christian, and actually DC-20, which was discussed earlier by my colleague Yusek Jesse Andres, is actually an output decongestion matter. Why? Because with DC-20 requiring that only quality cases, no harassment suits, no frivolous complaints, and no weaponization of cases would henceforth be filed unless and until we have the necessary pieces of evidence, documentary, real, and testimonial, and corroborative witnesses. Unless we have those, the fiscal being in the lead of prosecution and investigation would not allow the filing of cases. So the cooperation, coordination, and assistance between the law enforcement and the prosecutors is one way to ensure that only quality cases would be filed henceforth before us. And I'm glad to inform you, ladies and gentlemen, that from the time DC-20 was issued last March 2023, when at the time the percentage of conviction was at a pitiful 23-25%. Right now, we have seen a significant improvement. There had been traction in respect to quality cases, as conviction rate had been increased substantially to around 45 to 55%. And we are hopeful that by the middle of 2025, the percentage would still go up much higher. The idea here is to ensure that those people who are not facing cases with reasonable certainty of conviction, they would have to be brought out of the jail system. They would have to be released. The cases would have to be dismissed. So, this requirement would now ensure that the quality cases would be ones that would result to lower level of cases to be handled by law enforcement, lower number of cases with respect to cases handled by the prosecution, lower docket for the courts, lower number of cases of PDLs to be sent to our correction system, and it would result to a greater and peaceful, greater harmony and peaceful existence of our community. Now, another aspect of DC-20 that also requires quality cases only would be filed is the fact that there is now a higher degree of proof required for filing of cases, from a simple case or a low level of probable cause to a prima facie evidence with reasonable certainty of conviction. Let me stress that DC-20 actually covers specified cases only: heinous crimes, capital offenses, kidnapping, terrorism financing, and so on and so forth. But when we would be transferring, and we are already on the final stages of transferring preliminary investigation as we know it, as covered by Rule 112, and the Supreme Court, under the leadership of our visionary Chief Justice Alex Gesmundo, they already agreed in principle for the transfer of preliminary investigation and inquest to DOJ. So that would clear the demarcation and the delineation of authority between the courts and the prosecution. This would mean a new landscape in our legal jurisprudence and administration of justice. That is a segue, ladies and gentlemen, to my discussion on the output aspect of decongestion. Our department had been quite active in respect to initiation of reforms and changes meant to ensure that only people who are truly guilty would be made to bear. Our mantra that was created when we were in Geneva, when we attended the United Nations Human Rights Council Revalida, where we defended the human rights performance of our country for the past 5 years. We embraced the mantra of real justice in real time. What does that mean? It means simply, ladies and gentlemen, that no one should be the victim of a miscarriage of justice. And a miscarriage of justice to us is if any person would be made to be incarcerated unduly. No one here, I'm pretty sure, would want to be imprisoned even for 1 minute, especially if the case is frivolous, especially if the case is trumped up. And the trumped-up cases would already be a thing of the past because of the DC-20. That is the reason why I stated earlier, as a preface to my presentation, that DC-20 is actually both an input and an output solution to jail decongestion. But another aspect of our reforms that we initiated during our time is the matter of automatic dismissal of criminal cases in first-level courts. There's a problem with our PowerPoint. Hazel? Hazel, are you with us? Anyway, the automatic dismissal of criminal cases in first-level courts is mandated under Department Circular number 008 and as implemented by Department Circular 008-A Series of 2023. And the automatic dismissal would come upon a finding that the case that is pending before first level courts has no reasonable certainty of conviction. What will happen then? There will be a motion to withdraw information or a motion to dismiss. That will be filed by the prosecution itself. Of course, you may ask, who will decide whether or not a motion to withdraw or a motion to dismiss would be initiated? It would still be done through the usual review process of the different national prosecution services around the country. And the automatic dismissal will apply, as mentioned, to first level courts, municipal trial courts, metropolitan trial courts, metropolitan city circuit courts, and so on and so forth. There is a question as to the likelihood of automatic dismissal of cases before the second level courts, regional trial courts. That question is very ticklish, and that question may present a slippery slope. Why? Because cases before the second level courts are those that involve far graver offenses. And in our discussion with the Supreme Court through Chief Justice Gizmundo, we informed him that in the horizon, that is being considered. But in that probable situation, later on, we would have to make sure that there would be lesser chances of abuse, because cases of far graver in character and with grave penalties should be treated with utmost care and precaution. You could just imagine if a case would be the subject of automatic dismissal and the case is terrorism or terrorism financing or kidnapping for ransom and so on and so forth. The cases before first level courts are lesser in degree, ladies and gentlemen, and that is the reason why we made a calibrated decision to focus on the matter of dismissal of cases. Another companion remedy that we initiated is Circular number 11, which means that there would now be a rationalization of the bail system. Now, whenever the case involves an indigent accused or an indigent respondent, the bail recommendation would be based on 50% of the bail recommended, or in cases where that person cannot really even present evidence, he may be the subject of a petition for recognizance under the Recognizance Act. And in here, in the reduction of bail, the rationalization of bail, the highest amount of bail that could be recommended would be 10,000 pesos. Let me make this clear. The 10,000 is but a recommendation of the prosecutor. The final decision would still rest with the judicial processes, with the court, with the judge. Then that is under the concept, under the doctrine of Crespo versus Mugo. We don't deviate from that. We will honor the decision of the courts in respect to the recommended bail. So therefore, there is still a solution when it comes to cases of such heinous character, or if it is a case that would really be violative of our basic sense of modesty and our belief as to the family. For example, incestuous rape. Imagine if the offender in an incestuous rape would just be allowed to go out at a 10,000 bail, because that is the mandatory requirement under DC Circular number 11. We are forgetting the fact that the court is not bound by that recommendation. If he or she feels, the judge feels that that amount is so low because of the character of the offense committed, by all means, impose a much higher penalty or a much higher bail. In the implementation of these guidelines in respect to jail decongestion, ladies and gentlemen, we are proud to inform you that from July 2022 to November 2023, that was the time when we assumed office, up to the present time, BuCor had already released around 9,200 persons deprived of liberty. And we are continuing with that. The fact remains that in respect to the determination of who to release, it would be in respect to a review of their respective court records or prison records. That is the so-called carpeta. And the increase in the number of releases from BuCor was actually a realization of a promise we made before the United Nations Human Rights Council. When we went there last July, we promised them that by June, we would be releasing about 5,000 persons deprived of liberty. We were able to breach 5,000 by March. And in fact, and this is a far greater result, I would say that this is a much, much better success in terms of releases of persons deprived of liberty. What do I mean by that? We also required an attached agency under us, which is the Public Attorney's Office, to review all the records of their clients. A simple review of their clients' records, and to check whether or not there is evidence against their clients, whether or not the complainant still interested to pursue the case, whether or not there has been settlement, whether or not the accused even may have died in the meantime. So a review of that sort conducted by the Public Attorney's Office resulted to, based on POW records, and I'm not making up these numbers. Based on POW records, they were able to cause the releases of 50,000 as of March. 50,000 persons deprived of liberty. Apart from these efforts, the twin effort, the trifecta of interrelated measures or reforms, DC-20, the bail guidelines, and the automatic dismissal of cases with no reasonable certainty in first-level courts, we do have other efforts down the pipeline. We have plans for the construction of regional prisons. Why regional prisons? Because we know that the correctional and reformatory nature of our correction system would be better served if the PDLs would be incarcerated in the prison facilities that is within reach of their families. Imagine if someone from Jolo or someone from Batanes would be incarcerated in Bilibid. Perhaps in the first 2 months, he would be visited. But later on, nobody would even care about his existence. But regionalization, ladies and gentlemen, would cure that void in the lives of people. It would give them a chance at second life, a second chance at life. We have also been initiating transfers of persons deprived of liberty, PDLs, to new facilities. We are trying to discuss with with the LGUs for the use of their provincial facilities. And I think sooner than later, we really have to find a way to rationalize our correction system. It's only in the Philippines that you have 3 levels of prisons. One, a national penitentiary under BuCor, which is under us. Another, which is under the LGUs, which is under the Bureau of Jail Management and Penology. And we have the local jails. There is a need to centralize these programs in order that the vision of ensuring a correctional facility that is meant to give PDLs a second chance at life be realized at the soonest possible time. But there are also people who may not be the subject of reforms anymore. They may be beyond the pale of personal changes. And we have been thinking of establishing a separate facility for heinous crimes. Those people who have been convicted for crimes where there is no chance at a reasonable chance of being rehabilitated. Of course, there may be instances where heinous crime offenders may show a great degree of change, but that may be an exception than the rule. In order to ensure that PDLs would know their rights and that they would be able to pursue their legal claims and to seek redress and the possibility of being released sooner than later, we have been arranging for legal representation to PDLs. In this aspect, ladies and gentlemen, we have made arrangements with the Integrated Bar of the Philippines and civil society organizations that are composed of lawyers and other civic-oriented groups. They are there to ensure that they give free legal assistance to PDLs. And this is on top of the requirement of the Supreme Court of 120 hours to be rendered pro bono by all lawyers, and that is a requirement with the Supreme Court. I was privileged to attend a week ago the first Global South conference in New Delhi for legal aid, for access to justice and legal aid. And this is where I was able to explain, because we were given a 5-minute opportunity to present our experience, the best practices. And I was so proud and glad to inform them that as early as 1935, our Constitution already enshrined access to justice. Time is up. 1 minute. Single carpeta system. This is the most important aspect of our reforms. We have created a singular and a focused office under an assistant secretary to ensure that there will be a common program and application whereby all the attached agencies of the Department of Justice would be able to talk, quote unquote, in order to ensure that it's very easy for everyone to be able to avail of the benefits of all the reforms that are being undertaken in respect to the early releases of persons deprived of liberty. Thank you for listening and bearing with me, and good afternoon.
Thank you very much, Yusek Raul Vasquez, for a very informative subject matter. Our second resource speaker is Under Secretary Deo Marco, Department of Justice.
Hello. Good afternoon, ladies and gentlemen. My presentation will be quick, so I'll give you a few details about myself. So, konting trivia lang kasi inaantok tayo eh. So, before I became undersecretary, I actually was an actor. No? If you followed the TV series Provinciana, I was there since 2015. Yeah, we ended last year lang. And then another thing about myself, I have a new girlfriend. She's coming over. I'm going to invite her over. Pupunta. Ninong si Yusek Raul. She just recently broke up with her longtime boyfriend. Nakuha ko sa wakas. You know her, Catherine Bernardo. She's coming. Anyway, just thank you, Prof. Nara. Just to wake you up, because this is not the ideal time for a discussion like this, but if you, at any time during my presentation you feel like you're sleepy, there is a coffee station to your left, to my right, to your left. Make it black, make it strong, and so bear with me. So, ever since I became Undersecretary for the Corrections Cluster, I've been reading about and even dreaming about the words congestion, decongestion. But today, I'm going to talk to you about something else. Although it's related to congestion, this is about regionalization. So, do I have our slides ready? Okay. First slide. Okay. What is regionalization? Why do we need to regionalize? Why do we have to have regional prisons? And where on earth are we going to get the funding for this? The first two questions I'll be able to answer. The third, please help. So where's the first slide? Okay, let's talk about regionalization. What is regionalization? When discussing prison facilities, prisons or national penitentiaries, we are specifically referring to the facilities managed by the Bureau of Corrections, which has custody of the PDLs, sentenced to imprisonment exceeding 3 years. On the topic of regionalization, the term denotes the establishment of prison facilities, but just wait for the slide. Yeah, there you go. On the topic of regionalization, the term denotes the establishment of prison facilities in each administrative region, taking into consideration practicality and factors such as the region's population, land area, and other relevant aspects. The objective is to enable PDLs to serve their sentences or undergo preventive imprisonment in the region nearest to their families or other essential support networks. This was touched upon earlier by Yusek Andres and also touched upon by Yusek Raul. So that is the definition of regionalization. But is there a basis under the law? So let's go to the next slide. Regionalization of prisons has long been one of the long-term goals of the Department of Justice. This is the reason why there are now 5 national penitentiaries situated outside the National Capital Region. So we have the Leyte Regional Prison, the Sablayan Prison, Iwahig Prison, my favorite in Palawan, San Ramon Prison, Davao Prison. In addition, we have the Davao Prison Penal Farm also houses another separate facility for women, the CIW in Davao. Okay. The basis for the DOJ's greater thrust reinforced towards the regionalization of prison facilities is found in RA 10575 of the Bureau of Corrections Act of 2013. Further emphasized in its implementing rules and regulations, as well as the UN Standard Minimum Rules on the treatment of prisoners, or the Mandela Rules. So can we go to the next slide? RA number 10575 grants the BuCor the authority to propose additional penal farms in addition to 7 existing prison farms. So there you go. So we have the Director General is actually authorized by law to look for other places where we can build our regional farms. Subsequently, through the revised implementing rules and regulations of RA 10575, the department adopted a policy of regionalization and the establishment of facilities compliant with the Nelson Mandela rules. Next slide. Let's go. Yes, there you go. Finally, under Rule 58 and 59 of the Nelson Mandela rules, prisoners shall be allowed to communicate with their family and friends at regular intervals, not only by writing, telecommunication, or electronic means, but also by receiving visits. Prisoners shall be allocated, to the extent possible, prisons close to their homes or places of social rehabilitation. These are the main basis for the establishment of regional prisons. So let's look at the present situation in our prison farms. Next slide, please. As indicated in the 2022 annual report of the Bureau of Corrections, the organization managed a total of 50,126 PDLs by the end of the year 2022. Among this population, 92.9% were male and 7.72% were female. Mas mababait ang babae. From the period spanning 2013 to 2022, there has been a notable increase in PDL population with an average annual growth rate of 3%. So every year, there's a growth rate of 3%. So imagine, 5 years from now, ilan na yan? Let's go to the table. In its 2022 accomplishment report, the BuCor highlighted a congestion rate of 303%. Additionally, the report revealed that 8,113 new PDLs were admitted nationwide in the same year. Notably, 97% of these admissions were first-time offenders. So 97% were first-time offenders, which tells us 3% bumabalik. So it's not bad, no? 3% lang yung mga bumabalik. But still, we aim to go for 0. But right now, it's 97%. So it only shows na meron magandang reformation program si DG Katapang. Let's go to the next slide. The current figure, a growing population. At present, the BuCor maintains custody of over 51,862 PDLs nationwide, reflecting a 3.46 other factors such as buildings, floor area. So next slide. So it is evident that prison congestion primarily stems from inadequate infrastructure to house PDLs in accordance with established standards. While alternative solutions may exist, the Department of Justice is obligated to align with court findings regarding sentences imposed on PDLs found guilty of crimes. The DOJ must also respect the accuracy of conviction judgments unless overturned appeal by a higher court. So we now know what regionalization is. We now have the basis. We know the situation. Why do we need to regionalize? Let's go to the next slide. Okay, the primary objective of regionalization is decongestion. However, there are other advantages to the establishment of prison facilities in each region that would not be achieved if a single large supermax prison is established. Next slide. Prison facilities in smaller scale, distributed nationwide, offer several advantages in terms of prison management, such as improvement in efficiency, as cited here, may take the form of efficiency in communication and coordination with among officers. Basically, the smaller, kung mayor ka, the smaller your bayan is, it's easier to manage it. Efficiency in the implementation of security measures, not only because of its manageable size. This would result in the presence of corrections and reformation officers who share cultural connection. So it's when we have regional prisons, it's actually easier to entice people to become corrections officers. And because it's easy for them to go to work, diba? And they also understand the culture there. But the problem lang is they become friends with the PDLs, and sometimes that evolves into familiarity, which evolves into easier drug contracts. But that's the reality. But it happens, there are solutions to that, we rotate. But still, yung benefits of having regional prisons will outweigh those risks. Next slide. Proliferation and recruitment in prison gangs or organized crime syndicates will be affected. So if we have regional, in practice, no, this was also mentioned by Justice Miranda earlier, may mga gangs talaga eh. If you watch the news, aside from ang probinsyano, meron talagang gangs eh. May mga efforts ang mga previous DG to eradicate it, pero hindi talaga nawawala because we are undermanned. So we have to somehow rely on gangs because they have their own leaders, and we rely on those leaders to actually police themselves. So may benefit din siya, pero meron din risks. So ito yung inaaral natin. We're trying to avoid this as much as possible, wala nito. But that's the reality in the Philippines. We have to deal with that. We have solutions for that. From the viewpoint of PDLs, a regional prison which facilitates visit from support systems outside prison may reduce feeling of isolation. Ang decongestion, yes, it is ang regionalization is a way to decongest, but for me, the most important effect is yung reformation aspect niya. Because the closer the PDL is to their relatives, they can get visitors, they have something to look out for. Meron silang motivation, there's something waiting for me outside after I get released. Some people, because they're hopeless na, I don't have any job, my wife left me for another person. There's nothing to look forward to after you get released. What happens? They resort to violence, they resort to making money inside, all these illegal activities. And we are trying to stop that by giving them good reformation programs, and a big part of reformation is their contact with their loved ones. So this is what regionalization actually brings. From the viewpoint of prison authorities, large supermax prisons create a concentration of high-profile PDLs. So that's correct. Imagine, sabi nila, I was once told that there's this joke now, sabi nila, if you want to plan the perfect crime, go to Bilibid. Why? Because you imagine there's a round table, there's an estafador, carnapper, kidnapper. If you want to plan, all bases will be covered. And some people are some PDLs just not very receptive to reformation. That's why we'd have to separate these people. That's why, like in class, di ba? Two seatmates, the stubborn ones, they have to be separated by the teacher. That's what we're trying to do as well. If we have regionalization, the high-profile ones, those who are really stubborn and not receptive will be taken somewhere else. At least they're separated instead of them, planning the perfect crime, so to speak. Next slide. So it also encourages public scrutiny and enforcement of PDL rights and provision of legal services by private lawyers, professional legal associations, and civil society organizations. So increase effectiveness of reformation and rehabilitation. So that's the end of my slide, but I would just like to take this opportunity to report to you where we are now in terms of reformation. So, in terms of regionalization. So we have already, the BuCor had already identified many areas, different areas in different regions where we're going to place them. So venue, check. We also have already some documentation ready. Ililipat na sa, the properties will be transferred in the name of the BuCor. Documentation, legal side, check. We have the support of the local government. Sometimes they are the ones who actually come to us to donate their properties. So local government, check. We have the passion, check. Motivation, check. Money, X. So we don't have the money. So right now, that's where we are. But that's why we were very happy yesterday, when the speaker gave his message, as also CNOC, State Senate President, when they both said that they're going to support us with the Supermax and as well as the regional facilities. I hope that we'll be able to build at least maybe one lang or one or two per year. If we are given that budget, it will be a big help before we actually leave the BuCor and the DOJ. I'm really hoping that the DBM, the Congress, would support us. That's why we're very thankful for this JSCC. This is the best venue for us to, for all the bright-minded individuals to help each other and, call out kung ano yung mga kulang. And I really appreciate this first ever JSCC because now we are being, BJMP and BuCor, we are given somehow being attention. We're being, what we need actually are facilities. We can do all these facilities, we can have all those measures. As mentioned by Justice Monet yesterday, we're going to implement other measures like amending certain laws, like recognizance laws. These are good, but we also need the facilities. That's why we need to regionalize. Thank you so much.
Regionalization of prison projects that is related to the next topic on the initiative of decongestion to be presented by our third speaker, Jail Director Raul Rivera of Bureau of Jail Management and Technology, BJMP. Let's give him a round of applause.
Thank you very much, ma'am. To the Justice Sector Coordinating Council, composes of the Supreme Court, the DILG, the DOJ, other stakeholders, and all delegates present, good afternoon. The Bureau of Jail Management and Penology is thankful that all agencies and stakeholders that advance PDL's right and welfare have come together in this two-day summit to study the problem of decongestion in prison and in jails in our country. We have to explore approaches where we can work together as one nation, especially in the areas where our respective efforts meet to resolve overcrowding. We have prepared a short run-through of the BJMP, the status of congestion at present, our efforts to address it, the importance of collaboration with every sector of the society, sharing a stake in PDL development and in our plans for the future. And at this juncture, may I draw your attention to the screen for an audio-visual presentation. Roll BTR, please, and please dim lights. Please repeat, pakiano lang. Sorry for some technical problem, please. Anyway, in the presentation, we talk about the problems, how to resolve it, some initiatives of decongestion, and the strength of the BJMP as well as the data on decongestion, the developing term decongestion. Anyway, is it ready over there? Okay, it's ready. Then, the initiatives of the BJMP under the leaders of
13% are crimes against persons, 6% are crimes against property, and 5% for other crimes. On the data of cases per status, 90% are ongoing trials, 8% are city or municipal prisoners, and 2% are insular prisoners. Due to the congestion dilemma previously presented, and our desire to ensure the humane safekeeping of our PDL, we came up with several decongestion initiatives. In the year 2017, we had the peak average nationwide congestion rate of 612%. Can you just imagine having this data translated per jail unit? Imagine, a cell that is meant for 10 PDL is occupied by 60 PDL. Provided are the decongestion initiatives that the BJMP is currently undertaking, namely, coordination, construction, policy implementation, and transfer of PDL. Coordination with other agencies, private institutions, and stakeholders is being done by the BJMP to seek support, especially in crafting and implementing policies. Our agency also coordinates with the LGU for possible donations of lots intended for jail construction. For this initiative, the construction of new jail facilities and expansion as well as the repair of existing jails are facilitated. A total of 226 jails are constructed, 15 are expanded, 11 are ongoing construction, and 4 are ongoing expansions. Through these efforts, an additional 16,511 is added to the BJMP holding capacity. As shown are the policies being implemented in the BJMP that seek to decongest jails. We have the guidelines for decongesting holding jails by enforcing the rights of the accused persons to bail and speedy trial, Community Service Act, and the non-issuance of a release order upon completion of service sentence and submission of reports from authorities having custody of the PDL. This is the trend on the percentage share of paralegal releases to the total BJMP releases. On average, 80% of jail releases are through paralegal initiatives. The BJMP also has this initiative of transferring PDL from congested jails to not congested jails through coordination with concerned courts having jurisdiction over PDL cases. Through these efforts, we have successfully reduced the congestion rate by 43%, which is from 612% last 2017 to 348% currently. We can say that we have deducted the PDL occupancy by half overall. But still, some jails experience worse congestion, some even have 2,000% congestion. Imagine, in a cell good for 10 PDL, a total of 200 are occupying the same. Can you just imagine how is that? But the question is, how are we going to improve this further? The BJMP has developed long-term initiatives that are aligned with other strategies. These strategies and initiatives would have a big impact on congestion in jails. As shown are the specific desired outcomes. Through these strategies, we envision that by the year 2028, our congestion rate be reduced by 21%. This target is also anchored with that provided in NEDA. So, how are we planning to achieve this? Provided hereunder are the long-term decongestion initiatives. First, effective community reintegration leads to a reduced congestion rate. Second, national policies and bills enactment. And lastly, strengthen stakeholder engagements and breaking down silos within the criminal justice system. For the first initiative, which is the effective community reintegration that would lead to a reduction in congestion rate. Currently, our reoffending rate is at 20% nationwide. To simulate, we have a total reoffender of 27,678. The higher number of reoffenders is equivalent to an increase in congestion. From there, the BJMP has considered the result of effective community reintegration. Our initiative is to enhance our core functions, including PDL classification, to be able to give a needs-based programming and reintegration to assist the PDL in effectively going back to the community. Having no reoffenders is equivalent to a reduction of the jail population by 20,000. At this point, this is to discuss the second and third decongestion initiatives, which are interrelated. Let's discuss the potential contributors to jail congestion, specifically in the criminal justice system. Starting from PDL intake, possible consideration of alternatives to imprisonment and decriminalization of some cases may be considered for the arrested PDL not to undergo imprisonment, especially for minor offenses. Next is in the correction pillar. where we should improve PDL development through needs-based programming to ensure the meeting of PDL effective community reintegration upon his or her release. Last is the overall view of how each pillar affects each function leading to congestion. Specifically, several legal aspects. Increase in court cases, process bottlenecking, delays. These all lead to jail congestion. As shown are the list of proposed national policies and bills that have a high impact on decongestion, and some of these are already in the BJMP strategic plan for 2023 to 2028. This strengthened engagement among the Philippine criminal justice system would lead to reduced complexity of legal processes, no more information silos, lessened legal and privacy constraints. Change starts now. The BJMP cannot do decongestion alone. Indeed, it is a multi-agency initiative. Jail decongestion plays a vital role in promoting the societal well-being of the PDL and transforming the criminal justice system. By focusing on improved living conditions, rehabilitation, reduced violence, enhanced justice system efficiency, and cost savings, the impact of decongesting jails can be far-reaching. It is essential for the making of a safe, just, and prosperous Philippines.
So thank you very much. The presentation is about the current decongestion initiatives of the BJMP, as well as the developing long-term congestion initiatives and ways forward. And as you've seen, the Jail Plan 2040, or otherwise known as the Journey for Advancement, Innovation, and Long-Term Development Plan, which sets the BJMP's direction toward governance. And at the end of the road, we expect to see a highly capable agency dedicated to global practices, and also standards in jail management, which, of course, translate to a PDL population that have better living space, translating further into lesser health threats, more empowered PDL, and ultimately lives in humane condition behind bars. As we admit the sad state of our PDL caused by congestion, we are opening our gates to all of you to share in the urgency of us need to work together, every agency doing well its part in the justice chain. We have identified the culprits that give rise to overcrowding, and these are the mostly beyond the BJMP's control, as I've said. With this, I seek and call upon every agency and partners to agree on the long-term solutions to congestion and be strong and be linkages in the justice process. Overcrowding is a problem that breaks down not only the physical being of PDL, but more heartbreakingly their mental and emotional selves. With this cooperation, I have the strong hope that we could solve it. So, let us be and do what they need. Let's vote in for decongestion and reintegration. Have a nice day. Thank you very much.
Thank you very much, Jail Director Rivera, for a very wonderful presentation. Really an eye-opener for us to be inspired toward decongestion. Our General Gregorio O. Katapang, the Director General of Bureau of Corrections, BuCor.
Isang mapagpalayang hapon po sa inyong lahat. Baka nagtataka po kayo, marami akong dalang bouquet kung kanino ibibigay ito. Ang tawag po dito, vegetable bouquet. Opo, kasi pag inuwi nyo yan, pwede nyo nang gawing pinakbet. Pero napaaga yung bigay, so we're going down to give the Supreme Court justices a bouquet of vegetable bouquet. Pang ano lang, kasi sabi ni Deo, hindi raw siya makamove on kay Katnil. So hopefully, magbalikan silang dalawa. Thank you.
Si Boston.
Yan po mga gulay na yan, harvest po namin sa BuCor. So ginawa naming vegetable bouquet. No. So I'll now proceed to my presentation. To all esteemed participants of this summit, good afternoon. The purpose of this briefing is to inform you about the transformation that's happening in BuCor. As guided by our President, it will be a legacy for this administration and also a source of pride for the Filipino people. I was here I was here for 2 days, and I want to put bone and flesh doon sa pinag-uusapan natin. I have a timeline. I have to accomplish it by 2028. No? So as a background, since the establishment of BuCor, 1905, next chart please. We have 7 prison and penal farm. Ito po yung nakalimutan ng BuCor. BuCor is not only a prison, it's also a penal farm. So the first one was established in 1870 in Zamboanga. Dito kinulong yung mga lumalaban sa gobyerno during the Spanish time. These were Muslim and political prisoners opposed to the rule of Spain. And then we have in Palawan, 1905 or 1904. In Davao, 1932. Correctional Institute for Women, 1935. Of course, the new Bilibid Prison in Muntinlupa, 1935. What used to be the old Bilibid Prison is now the Manila City Jail. No? So binili po yan ng Manila City Jail, doon kami nilipat sa Muntinlupa. So you'll see that we have about 48,000 hectares. No? So 48,000 hectares, if we will be allowed to give half hectare per PDL, pwedeng 90,000 na PDL can have at least a half a hectare. So dapat wala talagang congestion na nangyayari sa BuCor. We have a lot of land, but we lack the facilities. The succeeding charts will show you the current number of PDL in the existing 7 prison and penal farms, including the occupancy rate that has become unmanageable. No? Next chart, please. As shown in the chart, the new Bilibid prison in Muntinlupa City has the most number of PDL. And if this remains unattended, what happened 2 years ago, BuCor imploded and it became a rogue BuCor, because you have rogue PDLs who became middlemen, and some officials, even the highest official, are now wanted for a crime of murder. So we are now 53,000. When I came in, we were just 48,000. Ang kasya lang po dyan is 12,200. So really, we are congested. So today, I will outline the key strategies and initiatives aimed at addressing these structural, cultural, and operational problems that we are now currently facing. Napabayaan po BuCor for the last 50 years. Ang pinakahuli pong kulungan na pinagawa, 1973, yung tatay po ng ating Pangulo ngayon, President Marcos Sr., ang huling nagpagawa ng kulungan. So that's why really 50 years. Bakit ba nangyari yon? 50 years na pabayaan o nakalimutan ang BuCor. So with this, I'm now tasked to present a medium-term development plan, because as soon as the President declared his Philippine Development Plan, 1 week after I already presented to Secretary Boying my BuCor Development Plan for the next 5 years. So ito po ang mga marching orders na nakasama doon, na pinag-usapan din natin dito ngayon. To align the President's Philippine Development Plan, we have created the BuCor Development Plan or Modernization Plan, which aims to make BuCor relevant, sustainable, and respected in the 21st century. We are promptly addressing the issue of overcrowding in our prisons, and we have begun temporary decongestion management measures by expediting the processing of persons deprived of liberty who have already served their sentence. Nakita nyo naman na kanina lang sinabi ni Yusek Vasquez, 9,000. Ngayon, 10,000 na napalaya. So last month, ganun po, nagpalaya po tayo ng almost 1,000. Pero ang problema naman po, may nag-report sa aming reception and diagnostic center kung saan yung reception do sa mga nakukulong, 2,000 naman ang nailipat sa amin ng BJMP. So really, it's really very hard to catch up with the number of PDLs being put to our prison. Yun lang po, mga ano pa po yan, mga sentensyado po yan ng 3 years plus 1 day. Dahil yung sentensyado na 3 years and lower, nakukulong po sa BJMP. So through this effort, we have the Bilislaya, pero we will double time, because in our coordination with the Bureau of Pardon and Parole, they told us that just submit the prison records to include their GCTA. And then right there and then we can decide whether this person can be given parole or he has served his sentence. So we will expedite as soon as we, as fast as we can. Our plan is to close the new Bilibid prison in Muntinlupa by 2028. And then we will transfer them to the less congested prison and penal farms. We are exhausting our resources. As you can see, we already transferred about 1,859 in Sablayan, Mindoro, Palawan, and Davao. And then, of course, the CIW, or Correctional Institute for Women in Mandaluyong, will also be closed down in 2028. We will transfer them in Iwahig or in Palawan and in Davao, where livelihood projects are awaiting them. For calendar year 2023, we already transferred 2,000 plus, and then next year we plan to transfer another 4,000. Really, this is quite expensive for us because to move them costs a lot of money. We hire a ship exclusive for them, and it will cost really a lot of money to transfer them. But we will make do of the situation. Coupled with this decongestion, we also continuously undertake enhancement of penal facilities in Davao, Palawan, Leyte, and Mindoro. Next chart. And then, as mandated by RA 10575, we will establish regional facilities in all regions of the country. So the chart shows the perspective of a modern prison facility, which is composed of the maximum security compound with a drug rehabilitation center, and then a medium and a minimum compound, a reception and diagnostic center, and also a correctional facility for women. The cost of this facility is about 4 billion. Next chart. And then to optimize our resources, we have created the BuCor Land Utilization and Control Management Office. Now we are allowed to do business or go to business. Next chart. We have a 365 hectare lot in Muntinlupa. The present value there is about 200,000 per square meter. So I think we can raise as much as 100 billion to start or jumpstart the construction, relocation, and replication of facilities in BuCor in Muntinlupa. As outlined in our development plan, we also propose partnerships, no? And as early as now, there are so many takers in our land. Especially, prime lot na rin yung aming Palawan, which is 28,000 hectares. It's a prime lot. Hopefully, we'll be able to sign an agreement with the PESA to make it an aqua industrial zone, PESA zone, and ecotourism zone. Next. And then we are also, as guided by the President, to establish a unified penal and correction system. And how shall we do it? Next chart. So right now, what we are proposing to BJMP is that those who are already sentenced, they give it to us. So I saw in their chart, there's a lot of recidivism. Maybe perhaps there was no reformation program. No? So if you give it to us, you'll make sure that they'll never go back to prison. No? Next. Of course, idalaw, livelihood, multidisciplinary. Ang daming tumutulong ngayon sa BuCor. Of course, the NGOs, the civil society are there. You are very welcome anytime. There's no need for you to have to pass a law, anti-torture, human rights bill, just for you to visit BuCor. In the absence of that law, you are already authorized anytime to visit. No? So that you can see what's happening in BuCor, because I know you will be part of our endeavor to make BuCor relevant, sustainable, and of course, respected. We want to win the respect of the Filipino people. Next. Of course, we're saying you that the President is on top of this. He wants us to be the food production basket. He wants us to be a climate change adaptation area, because there's a lot of mountains in our country that are denuded, and just say to us where the places have to be reforested, and we'll be there. And that is how we will make BuCor or the PDLs relevant. They have to give something back to society. We're spending 120,000 each for them, for their food, clothing, and shelter. So they have to give back something to society to make them relevant. And if they give back something to society, they become sustainable, and then they win back the respect of the society. Next chart. So as I stated earlier, very close ang aming coordination and collaboration. Of course, nandito si Yusek Caliso. They are really going out of their way, and we thank you, we salute you for your endeavors. Next. Ayan, in the future, we'll put up the Barrio Libertad. Wala nang kulungan. Hindi na rin sila tatakas kasi yung pamilya nila may bahay na doon. They will stay with their families while they're incarcerated. Because Palawan is so big, it's about 28,000 hectares. So they can have a new life if they want. So even if they already served their sentence and they still want to be with us, I'll put up a village for them, and then I give them lots to cultivate so that they'll have a new life. Of course, meron yung agri-industrial complex. The investors are also interested in putting up the clean energy in that area, and that they can be part of our endeavors. Next. So the long term, 2024, will continue to, next chart, continue establish we will establish a tripartite, because DNR has the land, DA has the capacity to teach us where to plant or how to plant, and BuCor has the manpower. So this will really be a great help for food security and climate change adaptation. So ito, we're looking and making great progress. No? Next chart. So and then of course may NEDA. we want to be assured that really this effort will be supported by the local government and NEDA for their long-term planning. In fact, I was asking them about the JICA funding in Nueva Ecija that the Japanese already offered, and we want to revive this agreement. It's a $1 billion facility package that they want to give, and we want to revive it. Next. So ito na po yung mga na-identify natin na lugar. The congressmen and the mayors are supporting me because they appreciate the situation, and then they want their idle lands to be planted. Next. So this will be also as a pet project of Senator or Senate President Subiri, because there's no more capital punishment. No, he wants us to put a separate facility for heinous crime. One congressman, Congressman Suarez, is opening an island in Quezon. So sabi niya, doon mo na lang ilagay. There is an isolated island. So you can put all the hard-headed criminals away from the population. Next. So we'll continue. Meron na rin kami na-identify sa DRT. We want to open up the Sierra Madre area. Of course, we have Sablayan. Ongoing na, may Supermax na tayo doon. Pero small scale pa lang. Of course, we have in Negros na nagbo-volunteer, Bukidnon. And then of course, we're putting up also a separate regional prison and penal farm for our Muslim brothers as requested by the Presidential Advisor on Muslim Affairs, because they have their own values and culture, their prayer time, everything. We have already one in Zamboanga, 1,200 hectares, so we're good. Next chart. So ito, it's about 6 billion. But kung ang PDL lang gagawa ng mga kulungan nila, we will save a lot. No? We will save a lot because they put up the hollow blocks, pinapaaral ko na sila ngayon na mag-welding, no? Livelihood. Pero sinasabihan ko sila, wag niyong ayusin niyo yung pag-welding, baka mamaya madali kayo makatakas. Alam nila ko. Tsaka siguraduhin niyo yung buhos talaga. Baka mamaya gagawa kayo ng tunnel. No? Anyway, we'll supervise them properly, but they will have livelihood. No? Next. So this is my battle cry towards a relevant, sustainable, and respected Bureau of Corrections, respected PDLs in the 21st century, bagong BuCor sa bagong Pilipinas. Magandang hapon po.
Thank you very much, Director General Katapang of BJMP. Looking forward for the 5-year and thereafter the modernization plan of Bureau of Correction.
Good afternoon and thank you very much. Palakpakan po ulit natin yung panelists sa plenary session 4. Can you hear me? Medyo mataas po. Ayan. Okay, this afternoon we will be advancing our watches. So we will start with the breakout sessions at 2:30 p.m. if that is okay. And please be back here for the closing ceremonies at 3:45 p.m. Okay, so please proceed to your breakout sessions now. And those who are assigned to the ballroom, please move forward except the center table. Thank you, everyone. Thank you po.
Wait, tignan ko siya dito. Hindi ko din siya nakikita delo dito. Saan na siya? Wala si Justice Jolo. Simula na siya.
Yeah? Eh, ano, papa-move forward ko. Pagka, ano. Sino pre-prepare? Sino mag-pre-prepare? Nasaan ba siya? Pwede nga. Announce na ako. Hello. Hello. Good afternoon. May I request the participants of Workshop 14 to move forward, please. Yung participants po of Workshop 14, please occupy the seats available para po close tayong lahat. Thank you.
Check hey.
Yung slides niya, nandiyan siya.
Check hey. Testing. 1, 2. Testing.
Gusto mo dito na ako?
Check hey. Test hey. Hey. 1, 2. Testing. Check hey. Hey.
Again, may I request some of the participants of Workshop 14, you can move forward, occupy some of the vacant seats and tables, please. Thank you very much. Huwag lang po yung gitna. Darating po si Chief. Thank you.
yung pau ko. Halika, halika dito, attorney. Sige, halika dito.
Attorney mo ko na, Your
Ano
Honor.
po? Naging student ba kita? Hindi.
Hindi po.
Sige. Saan tayo? Dito. Abot dito pa yung next time. Sa gitna si Justice. O, yan. Si attorney sa gitna. O, sige. Sige dyan. Dito na lang ako. Sa Jimmy pa. Ayos siya. Opo. Thank you po. Let's just wait for our speaker. Parating na po. Kala niya 2:45 eh. But he's on his way. Thank you. G91. Wala pa ba? No? G91. Okay. Thank you po. That's Jimmy. interactive data. Sa PIO ka mo. Ikaw yung nag-introduce last week sa ano? Judicial Farms, no? Ikaw yung host. Magaling ka. Magaling. Kinabahan ako na tinanong. Hindi ako na magaling. Well done. Ha? Yun nga daw, interactive daw. Yeah, sure. Up to 3:45 tayo, no? Ang callback. Yeah, and ano, I don't think it'll take long. Konti lang slides eh. Well, let's see. Yeah.
Yeah, we still have time. We still have time. Kasi 2:45 siya na lang. Kaya ayaw niyo mag-move. Ang hirap nito eh. Spanish. Baka nasa holding.
Well acknowledged. CJ. CJ? We'll wait for him. We'll wait for them. Yeah, ganda lang daw. Exhibit. Ladies and gentlemen, let's please acknowledge the presence of our Chief Justice, Alexander G. Gasmundo. the other side. Okay. Okay. I'm looking forward. Okay, I'll introduce you. Okay, good afternoon, everyone. Welcome to workshop number 14, entitled Reforming Pretrial Detention System in Mexico, Constitutional Interpretation and International Standards. Okay. Our topic today will be discussed by a very seasoned district judge of the Federal Criminal Justice Center in Querétaro, Mexico. Okay. He specializes in legal education training, not just in Mexico, but as well as in Panama. He has co-authored several books and articles. Chief among them is The Relevant Legal Issues of Mexican Constitutional Law, and articles in mercantile orality and amparo law. He has a doctorate from the Instituto Universitario Puebla, as well as a master's degree in constitutional law and amparo from the University of South. Ladies and gentlemen, let us all please welcome Judge Eduardo Alberto Osorio Rosado.
Hello, everyone. It's an honor to be here. Magada Hapon Po. It's an honor to have the opportunity to address to all of you, people that it's working on the criminal justice or justice in general, all the authorities. And I'd like to thank my colleagues, judges, justices from all over Philippines. And of course, I would like to acknowledge and thank the presence of the Chief Justice Gesmundo. It's an honor, sir, that you'll be attending our lecture. So let me begin like this. I have already the opportunity to visit many courts. I've been on Judge Taylor courtroom. I've been on the Judge Marlowe courtroom also, attending to some hearings, some criminal hearings. And I could notice that there's a lot of opportunities to improve our criminal justice system. And I say this with a lot of respect, because the system is working just as Mexico's system was working only 7 to 10 years ago. We had a system very similar to this one. The criminal system criminal process was exactly like this. You go as a defendant to a criminal process in detention, arrested, or it includes being deprived of your liberty. But we've never thought about it in Mexico. We thought that it was normal. It was the procedure. It was the legacy because of the civil law that we inherited from Spain. But in Mexico, there was a big reform in 2008 that it was implemented until 2016 completely. And we adopt an adversarial system that changed completely the vision, focus. We're focused on other stuff. Let me present to you this. Can I? Where? Okay. Is it showing? Okay, thank you. This is more or less our criminal process. I know that the letters are so little, but I'm not going to focus on this only. Our criminal process by the Constitution have these purposes. The facts clarification, no longer the seeking of truth. And this is very important. No longer the seeking of truth. You know that the seeking of truth, it involves judges' faculties or capacities for making questions, for ordering the seek of evidence, and a lot of institutions that are now compatible with the adversarial system. So these are, by the Constitution, the four purposes of the criminal justice system processes. Facts clarification, repair the victim's damages, avoid impunity, and all that had to be done or achieved by protecting innocent, by the principle that you all know, innocence presumption. So all that have to be achieved like that. So in the process, the defendant, it is called now to a process by a subpoena, or if he doesn't attend the subpoena, he is called by you can be helped by the police, but it's a help. They locate him and invite him to go to certain date. Or if any of these results, your last resource is an apprehension order, a warrant for the arrest. So he have to be taken like that to the process. When he arrives to the process, these purposes can be compromised by the conduct that the defendant assumed. And this is recognized on our law. This can be the risk that can come to life by the conduct of the defendant. He is free under process, but if the prosecution prove that there's an existence of any of these three risks, risk to elude the process, risk to obstaculize the process or the investigation, or the risk that he makes a bad influence or victims, witnesses, or in society, then this brings to life something called necesidad de cautela, that can be translated as caution need or need to prevention. When any of these risks comes to life, we have the caution need or necesidad de cautela. So this caution need the legislation create some instruments or some tools so you can mitigate those risks. And those instruments are called precautionary measures, medidas cautelares, precautionary measures. Our law, our penal process code, have 14 precautionary measures that are those precautionary measures goes from the obligation of the defendant to report to an authority, I think that you call recognizance, something like that, recognizance, to pretrial detention. But this is the last one. And they are not put it on this order of relevance arbitrarily. The recognizance, the need to report to an authority, it is the less, it is the softer one, to say it in some way. I ask apologies if the terms that I'm using are not very sophisticated or technical, And the last one that you can use, it is the pretrial detention. Pretrial detention is no longer the way or the condition that you have to be in a criminal process. But it is the way that you have to be in a criminal process. You went into the criminal process on pretrial detention and you stayed like that unless you bail. Yeah? That was our system. Or there was several crimes that were not non-bailable. Okay? But you had to stay until you bail, or you had to stay all the process if the crime was not bailable. And our process were lasting like here. 1, 2, 3, 5, 8, 10, 12 years. So the defendants, the people, our citizens, our connationals were in prison while their trials were ongoing. And it was okay for us because we didn't have any reference or any parameter to determine if that was good or wrong until we adopt this new system. So the last process or a previous process was a pretrial detention general rule, and you could get your liberty by bail, for example. But the bail, what's the purpose of bail? The purpose of the bail that we have is the same purposes that I see with you. It's paying your way out of the prison, of jail, because we said prison to all the types of, you say you have jail for ongoing trials or penalties up to 3 years, and prison for people that are convicted with a sentence. But practically the bail was paying your way out. So the bail in the new process have a new purpose, that you give an amount of money that you care to maintain or you are not happy to lose, so you can guarantee that you are going to be present during your process. That's the real purpose of a bail. But the bail as has been used now, as we used it before, it is paying your way out. It doesn't pursue that purposes, or that purposes was lost throughout the decades. Because there are peoples, we could see at least 1,000 of the 3,900, more than 1,000 that can bail, can be free paying a bail in the city, Manila city jail, that cannot go out because they can't pay their bail. So we are punishing poverty. We practically punishing poverty. We are practically punishing lack of opportunities. We're not making any good like that, because we are overcrowding prisons with people that can be out. So we need to find some other ways to guarantee that that person will be attending to his trial, not only bailing. Because I know that there's organizations that reunite the resources, economical resources, to pay their bails. Come on, let's think about this. If someone comes and pay your bail, it's great because you're going to get your liberty back. But you are not attached to the process because it didn't cost you. It's not your money. You don't care to maintain that money or lose it. You're going to be out. You're going to be happy to be out, but you are not feeling compelled to attend to the subpoenas to the court. So we have to think deeply about the bail system, about the way that we are maintaining our people, our citizens on jail while the trial is ongoing. We have also on this system a hearing where the judge have to If the people is arrested, it is taken to the process, arrested for being caught committing a crime, there can be more than 48 hours before that person is presented to a judge, where we have to qualify the lawfulness of the arrest. Not legality, lawfulness. Human right respect, not only the penal codes, rules, or law rules. Human rights. And if the arrest, it is not good for qualify, you can send the people to his house that moment. So I was attending to hearings where people have 11 months on the process without the opportunity that the judge intervened there, resolving or making a resolution about his arrest, lawfulness of the arrest. So we're keeping people where we are gonna see how they were arrested months before. And we're setting hearings because of the system and because of the enormous number of carpetas or judicial processes. We cannot set the hearings for the next week or the next month. They have to be set months. So what about the innocence presumption? We are putting people on guilty condition while we see if they're guilty. We are putting people in a punishment condition while we see if they need to be punished. And we are not aware, or we are not thinking on all the collateral damages that the pretrial detention makes. If there's people that have lack of opportunity, it is in poverty, the collateral damages are suffered equally for their families. Because now they have to provide resources for the people that is on jail. The jails, I've seen great judges, great wardens and personnel from the prisons that are using this creativity to manage that chaos and keep it on respect, discipline, order, and they are doing great jobs. But the state can provide what the people need inside. So they have the inmates, the defendants have to be organized, so they have resources from outside to build their second floors, for example, so they can feed more. And my God, what is happening? It is not worrying us to have the people in that condition. We are creating a problem. There's studies that prove that there's a direct relation between reformation and the way that you treat a person on prison. If you have them in worse condition, they are gonna be worse reintegrated to society. The way that we have our prisons here, our jails, are, if I'm allowed to say it like this, but are farms, and we are cultivating anger on people. We're cultivating anger that we will harvest because humans, come on, we were all kids, we were all young, we all had problems. How many times did we realize that many of our behavior was influenced by the things that we lived before? We unconsciously were acting sometimes as rebels. Oh, come on, we were all good here. I think that it even makes us better judges or better public workers when we have lived a life even with problems, because it makes us more sensitive. But these people can not reintegrate well to our society and unconsciously develop behaviors that harm society other than create a good. We have in our jails people that it is falsely accused living with others, and they can be contaminating themselves by living there in those conditions. So we have to find a way to solve this, because it is not proper to a democratic country to treat their defendants like that. Do you have family process, civil process, civil matters? You go to a process in liberty. Why do you have to go to a process, a criminal process, without your liberty? Only bailing your way out. Why? It is a process also. Sometimes in a civil process, you can lose more than in a criminal process. You can lose your house, you can lose your sons, you can lose your rights with your family. We have to sit down and think about it. We need to change this. So these tools, this pretrial detention, have to be used only when this risk, any of these risks, these are proven by the prosecution. But you know what? I told you, pretrial detention is the last one. So there are international standards about pretrial detention. For example, we belong to the Inter-American System of Human Rights. I know that you know. And we have an international court for the countries that belongs to this system. It is called Inter-American Court of Human Rights. This court have ruled that there are standards for the pretrial detention. They say, we accept pretrial detention only if this pretrial detention accomplish this. Only if it is used exceptionally. Exceptionally doesn't mean that you use it on the 10% of the cases or 5% of the cases. What is exceptionally to this international standard? Use it unusually, that the use are unusual. Unusual, one of my colleagues said, this unusual should be equal to be tell in the news, a judge rule or establish pretrial detention. That unusual have to be, that it have to be transmitted on the news. But the use is being more general, as a general rule, than an exception. And the news are showing the judges that don't apply this. Because our vision of the criminal system have to be hard, have to be a pretrial detention, have to be a hard hand, have to be have to punish people. No? That's our vision of the criminal process. Not a human process, a humanized process, but a hard process. So it have to be also necessary. So you have to use it only when other measures cannot accomplish what you try to do. The presence of the person there, or that he doesn't obstaculize the investigation. It has to be proportional. You can put pretrial detention for any risk. For example, if I'm allowed to do this, and I know there's big authorities here, but if you allow me to use an example, maybe a common example, let's imagine this. Imagine that among us, you know, there's a coffee break outside. Imagine that we have cookies outside. There are no cookies. But imagine that we have cookies with the coffee. And among us, there's a big cookie eaters. There are putting in risk our capacity to get cookies when we go out. Okay? So we try to solve this. What can we do? Okay, where are our heavy cookie eaters, for example? Now say, I don't know, someone raise a hand. Okay, we have there the people that we have see as the big big cookie eaters. How can we solve this? You know what, ma'am, please, this person, you have to watch out that he don't go to the cookie table? Or what else can we do? Sir, please, ma'am, please, madam, please, you can only have one cookie. We're gonna watch that you have only one cookie. You can go there to the cookie table with a bucket. We're gonna watch out that you don't go with a bucket because we know what you do with that bucket. You fill it up with cookies. And we are in a risk of hunger. We can not be able to get our cookies for that. But we can also say, okay, coffee break. Where are our cookie eaters? Oh, there? Yeah, lock them up. We will accomplish that because they won't go to the table to get cookies. Is it right? But it is not the only way that we can accomplish that. There's several ways to accomplish that. That's proportionality. We have to use the precautionary measure that can mitigate the risk that is proven by the prosecution. For example, he can obstruct just the investigation. He can destroy evidence. Oh, let's lock him up. Okay, locking people up, putting them on pretrial detention will solve any problem. Yeah. But it would be no proportional. So it have to be set temporary. But temporary is not for as long as the process goes, because it is being set because of the existence of a risk. So it have to be to mitigate the risk, but the risk can disappear. For example, I don't have a home, or I'm from Mexico, I'm gonna go back to Mexico. How do we get that I can be present in the process, I can go back to Mexico? Okay. For example, we're gonna forbid that you go out for our country. We're gonna ask you to deliver your passport. We're gonna forbid I don't know, we can use another measures, you know? And only by the time that my risk disappear. For example, I can go to Rafael, I can go to another and said, you know what, I want to rent a house. And I want to make a contract so I can justify that I'm gonna be living here and I'm gonna be on the process as many times I'm quoted or subpoena. Yeah? So it have to be temporary. It cannot be used by the type of crime. We have a catalog of crimes that we consider unbailable, and this can be considered of pretrial detention, mandatory pretrial detention, because we have in Mexico mandatory pretrial detention. But we have also these standards, so we, the judges, can interpret the law and go for the standards and do not apply the mandatory pretrial detention, because it is not be asked for the existence of any risk. It is being asked only because of the type of crime that you're being accused of committing. Even before there be proven if you commit that crime or not. And cannot be established because of the gravity of the crime or the conduct. And also can be used an anticipated conviction or penalty. Oh, Your Honor, you know what? We have enough evidence that this person will be convicted at the end. So let's have him already in pre-trialization. No. If you're going to prove that, he's going to have a sanction at the end, a penalty at the end. Let's make the conviction at the end, but we are not anticipating the penalty in the process because we are violating human rights. This is the new understanding that we have that we have come in Mexico, and people, it is facing their processes on liberty. The prisons are being decongested because it is not the general rule. And it is all because a new understanding of the criminal process. And you know what? The people goes to their hearings. I have people processed for kidnap, for example, that can get a penalty up to 90 years, and they are going to their hearings on liberty with no bail. With the years, I have only used the recognizance, this obligation of report to an authority. And the people go and do it. The people is showing that they are going to be present on their process. If we give them the opportunity, they can show us that we were wrong about the way that we conceive the criminal process. So, what I've seen is very committed and professional people here in Philippines, but with a system that is no longer working or responding to our times, to our human rights era that we are in. It is not, I don't know if the word is congruente, consistent with our human rights speech. The human rights are something on our speech and other thing in our facts. That's not according to our human rights speech, to our human rights acknowledge, to our human rights época. It's okay? Thank you. So, even having the best judges, the best wardens, the best authorities, we have a system that can give us what we can give because of capacities or professionality. And if I'm allowed to show it like this, you know, the pinnacle of the races are Formula One, yeah? The best pilots are on Formula One, right? We have Checo Perez, of course, Mexico, I had to include him. We have women also. Philippines have a lot of personality, female personality. I love that. There's no only male personalities like in many countries. I really like that. And I have seen great judges, female judges, inspiring female judges. But these people, even with their extreme capacities, need this to accomplish their goals, yeah? So even with our professionality, we need this to achieve. And we cannot achieve even being them with this. As much as we are good, we don't have the tools to compete. So in this analogy, in this example, we are them. This is the system that we need, and this is the system that we have. We have to change this because we have this. And in the world, there is this at our disposition. We have to only go and get it. Examples are all over the world. So, I saw another problem. A problem that is occurring here, it is drug possession and drug consumption. Come on, let's change our mind also. Drugs are something that the people have developed a dependency. It is since the 80s or the 70s recognized for the OMS, International Organización Mundial de la Salud, Rafael, National Health Organization, the World Health Organization, as a disease. It is a disease. So we are criminalizing disease by, I could see it, 0.1 grams. Come on. And, because we are putting a vision only on morality. Oh, that people is wrong because he's doing drugs. But how many of us have dependency to another stuff? Coffee, chocolate, Coca-Cola, and other stuff. But these drugs have chemicals that makes them very addictive. It is all part of the process. And these people should not be criminalized, should be treated by the state, should be helped. In Mexico, there's an important precedent of last year of the Supreme Court. I will be happy to share it with you. I can be a partner with you if you want. I'd be glad to do it. And I could address to you to let you know this judicial precedent, May 2022. And the Supreme Court of Justice of Mexico understood that the people consume drugs for two reasons: because they want to and because they have to. And they say if they have to because they have a disease, they need it for their health and their life. Because a crisis, this crisis, when you don't consume drug, it can take you to death. Okay? I don't know if it's, you know what I'm talking about, yeah? Se llama, ¿cómo, Rafael, este tipo de ataque? Cuando la gente deja de consumir y necesita la droga. Well, yes, that syndrome, yeah. That's the idea, okay. So, the Supreme Court said we have a metric system of criminalization. We have drugs on the list, and we have amounts of drug on the list. And the law says, if you have this amount, it is for your personal consumption. But if it goes beyond this amount, it is not for your personal consumption. This law comes from 2009, and the court says that law is arbitrary. That board, that metric system is arbitrary because it is setting the consumption of the people that can need more than what is that amount. We don't consume the same quantity of coffee. Some people said, no, I drink my coffee in the morning and I can't drink anymore because I won't sleep. And there's people that can have the coffee on their bureau, drink it and go to sleep. Well, we have different biology. The same happened with drugs. I have asked people on my courtroom, and this is curious. We think that they know the consumption about grams. They don't know about grams. How many grams do you consume? Grams? I consume doses, they say. Little bags that I buy. They don't know how many grams are in there. And I said, how many grams or how many doses do you consume? Sir, I smoke as long as I need. I can smoke 9 doses, 12 doses. Depends on if I'm happy, if I'm sad, if I'm depressed, if I'm on party. So this metric system is now reflecting what the people is really need to their health. In the jail system happens something that we can use an example here. There's personnel attending us, yeah? And there's a number of us here. But what happened if in this room would be 200 or 300% more people than the people that is here? We couldn't be accomplishing the goals of this summit because the personnel would be no enough to serve us, to attend us, to be aware of what we need. That happened on jail. The jail system is now accomplishing their goals. The prison, it is not accomplishing this reintegration of the people because they are managing chaos. They have to develop systems for the people not to harm themselves. That's what it caused the overcrowd in jails. So I want to make that we all think about this. I prepared this video, and we are going to see first a video of Alcatraz, a prison we know in San Francisco, then the prison when Mandela was here. This is Alcatraz right now. This is the way the people live there. And this is Mandela's prison, but this is an advice, an advertisement of the government of South Africa. Come, and part of your visit or your tour, your culture, come to visit the prison. And this is here. This is the dead corridor, the dead row. Okay? In Believe It facilitations, yeah? There's something common between Alcatraz, between Mandela's prison, and this dead corridor. They are all museums. Okay? They are no longer in use because of the cruelty of the conditions that they represent. They are museums. But only across the street of that museum, here on Believe It facilitations, there's an active prison, Believe It prison, with 29, almost 30,000 people, overcrowded by 400%, with with lack of personnel by more than the percentage of the overcrowd, the one that they need. And I have a thinking that day. How long is going to take us for our prisons become museums? As a reminder of the way that we treated the people that committed crimes. How long? It can be unthinkable for us. It can be, no, that's good now. That it's okay now. Oh yeah? What the people that make the dead corridor, the dead row, thought on their times, that it was okay, that it was the proper way to punish some crimes. I was told that the last death sentence was on 2000, 2001. Yeah, 2000, 2001, only 20 years ago. Only 20 years ago. And we are no longer using this because we think that this is cruel. We understood that this is not the way. Killing our problems, it is not the way, because maybe we are co-responsible of the behavior of the people. So we cannot kill what we helped to create or couldn't help to be developed. That's the way that we have to think. But what about the people that is across the street? How long is it going to take us to acknowledge that that is not the way that we have to treat, at least not all the crimes that we are now punishing? For example, drug possession. I knew one people there sentenced to life for the selling of 0.1 grams of shabu. Come on, life for that. That is going to be in 20, 30, 40 years, says like, what? That was happening then? Thank you. So, let's keep on watching this presentation. Just across the street is the active prison. And this is the way that we have people in Philippines. This is the way that we have to, we think that we have to have people in Philippines. This is what the world is watching. But this is Norway today. Those are inmates in Norway. They are convicted. That's a prison there. I know what you're thinking. I would like to visit hotels that be as comfortable as this, as luxurious as this. We sometimes go to a hotel that doesn't have the facilities. Okay? We're seeing Norway, and we're going to see also Finland. This is the way people smile. Finland. Those are cells in Finland. Where's the people? How many Philippines we would have there? Like 60, 40? Where's the people? Where's the overcrowded? Those are prisons. That's a prison in Finland. That's another one in Finland. That's people on their visitations. That's a prison cell also. That's visitation on the weekends. That's a person sentenced to life for murder. That's the food, I know. We're sometimes not having that good food. That's a prison. Come on. So, the world is evolving on the way that they conceive, that they think about the crimes and the way that you have to treat the people that commit crimes. How long will it take us to go there? I would like to make an example, so I need 6 volunteers, please. It won't take no longer than 2 minutes, please. Or we can say Chief of Justice to say voluntarily who's gonna come here. Aha. He don't want to use his authority, but he's gonna use it, I'll let you know. Does anybody want to help me? Would you please? Would you? I'm just gonna show something. Would you please? I need 6 persons. You could be one if you want, please.
Sure.
Yeah, thank you. Thank you, sir. Thank you. Thanks a lot. Thank you. Now, Judge Taylor, please come. I'm attached to a time, but yesterday I won't say who, but in certain workshop, certain judge interpreted time and got like 25 minutes more. I won't say who. Judge, please come. Judge, please, Judge, come. No, come. We need no. Ah, your fellow females didn't want to come. She's the only one representing women here. Come on. Let's have it for Judge Taylor. Ah. Okay, Judge, please, here front. And you behind the judge, please, like this. And like this also, please. Thank you. Yeah, thank you. I'm going to do this to show, to prove a point. So this is what is happening now. Imagine people on prison, convicted in prison, with minor, medium, and extreme sentences. Yeah? Okay. When they are declared guilty, they will have a conviction, they will have a penalty, okay? So these are minimum penalties. So if he reach her, okay, there's the penalty, the same, okay? This was death penalty. Yeah? Okay. Lower your hands, please. And let's show you evolution. This is what is happening now. Okay? The death penalty cannot reach anyone anymore, okay? Yeah? But the evolution cannot be only here. The evolution have to be also here, because they have to be also some conducts that cannot be longer be penalized by the criminal law, yeah? Like, for example, drug consumption in the personal use, or any other conducts that have us as a society criminalizing people, yeah? Evolution have to be not only for that penalty or that kind of cruel penalties. It have to be this way also, yeah? Thank you very much for your help. Thank you. Thank you. Thank you. So I would like to finish, because I have, okay. Okay, I saw. I would like to finish with this reflection, is okay? Yeah? There is something that distinguishes Asia, that we admire in our countries of Asia. It is something that we would never develop in our cultures because it comes with you for 1,000 years. And it is commitment, professionality, it is discipline. Oh my God, you are so disciplined people that we admire that, and you have developed it for 1,000 years. But there's also one honor. I see in the way that you salute the other people, the way that you address to other people. The honor is something that guides your life, your conduct. So I want to tell you something. I would like the people from UNODC to raise their hands, please, and stand up. Sophia, ma'am, please, yeah. Is there people from European Union and Australia government here? And I'm gonna ask you something. Take a look of them. They work to make this summit possible. They want to change the world. In the history of mankind, the UN has a protagonic role. And I'm gonna ask you something. How are we gonna honor them? How are we going to honor their efforts, their sacrifice, their work to make this summit? To don't be void, to don't be sterile, to don't be useless. This can be a 2 days event where we dress well and come to drink coffee and hear good lectures or bad lectures. This have to be something that define the way that we're gonna act tomorrow. The year is ending, comes holidays, and this can be fade in the time. Let's set some reunions to revise what we're doing and change it. Let's honor them. Let's show the honor that distinguish the Philippines, and let's honor their efforts. It's been a real honor being invited to share with you what we're doing in Mexico and give you a perspective of what we're doing in another country. This is the first time that I'm in Philippines, but I know about your country decades ago. Like, I am working on the judicial branch of the Federation. I live in many cities in Mexico, and I live in Acapulco. And Acapulco have a strong connection with Philippines. I don't know if you know it, but yeah, exactly. La Nao de China was called one famous boat that this galleon trade. And there's a yearly festival that is celebrated in Acapulco that celebrates this boat trade, galleon trade. And there's a lot of festivity during a week, 2 weeks, with the Asia culture, Philippines culture, and Mexico. So, although we are separated by 14,000 kilometers, we are really bounded or united by a history that can be broken. It will never be broken. So it's a pleasure, and I hope that I've been helpful. And I'm offered to be a partner to keep on helping you to improve our legal system.
Thank you very much. Thank you very much, Judge Osorio Rosado. We still have a few more minutes to entertain your questions, queries, details. Anybody?
I think that, or I make my point, or I didn't make my
Yes.
point.
Yeah,
Because
I guess. Yeah. Anyway, so maybe to recap and maybe to react to what Judge Rosado was saying, he's really telling us to have a change in mindset, to remember that bail is, well, he has opened my eyes, and I guess he has opened yours. You know that it's there, that bail has really become restrictive on our part. He's opened our eyes in the sense that, well, bail shouldn't be just a way of paying one's way out of detention. When you speak of detention, there's no final sentence yet. It should not be a way of really punishing a person who is yet to be punished, who enjoys the presumption of innocence. Our good speaker has told us to change our mindset, to trust and remember the purpose of bail, which is what? To guarantee one's presence during trial. And he tells us to explore the possibility of us being assured that whatever steps that we take, the person who is undergoing trial will attend trial, and that bail should not be restrictive.
I know that acting different, it takes consequences. I know it well as a judge. But changes requires courage, requires creativity, requires the courage to act differently and to use another measures to change. It was Einstein who said that if you want different results, you have to stop doing always the same thing. So if we keep on doing the same thing, we are going to have always the same thing. Is it or is it not that we want to accomplish what Norway wants, what Norway have, what Finland have, what Europe have? It can be done treating our people like this. And we want Norway or Finland or that in every aspect: economy, infrastructure, the cultural, caring of your environment. Well, we will never do it treating our people like this. We can be invited, you can be invited to my house and said, oh my God, he's great. He's a good person. But then you ask for going to the restroom and you pass for a room and I have my family in a room in that condition. Or I tell you, no, for me it's important to my invitees to see that I'm worried about them, that I care about them, but everything is dirty on the way, everything is broken. How can this be correspond to that? It is not. So how can we say that we are a country or people that cares for the human rights, having our prisons like that, or having our courthouses like that? In the stairs, you can notice how important it is for the state, the legal system, heat, no good conditions on their buildings. It says more about how important it is for us. So big changes comes with the little actions. So we could change the world by making those little changes, those little actions. And here in the room is the people that can do it. For changing things, we need to find ideas, we need to find a way, and we need to find the precise words to be spoken so we can see what we have to do. In this forum, since the presentation, since the opening, the exact ideas has been exposed and the precise words have been spoken. So all that we need, it is to take action. And it is up to us. No one is gonna do it for us. It is up to us. And we're able to do it. We are those Formula One racers, but we just need to get that car, that system that can make us competitive. Thank you.
Thank you very much. So with that and without any questions, we now formally end workshop number 14 and move over to the closing ceremonies. Thank you very much, everyone. I'm your moderator, Jolo De La Rosa. Thank you.
Check, hey, testing. Check, hey, 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 hey. Tsaka yung magsasalita doon sa kabila. Para yung mas malakas lang sana ilalagay ko. Check, hey, hey. Check, hey, hey.
baba naman po to. Mataas. Ayoko ng tunog lata. Ayoko ng tunog lata. May mga tunog lata ka kanina.
Check, hey.
Good afternoon, Your Honors, Your Excellencies, ladies and gentlemen. Sinong workshop yung natapos ng 3:45? Ballroom, present? Very good kayo. Ano pa yung isang workshop? Thank you po for ending early, kaso wala pa po yung iba. So how can we start with the closing ceremony? So reminder please, pakigather na po lahat ng workshops. We will proceed to our closing ceremonies. I know you have a long weekend ahead of you. Bawat isa. May minutes ka na. Ilang minutes yung video mo? Tapos yung speech ni sir, ilang minutes? 3 pages lang ha. Kasi ngayon ko lang nalaman yung video, nabigay mo na dun sa tech. Hindi ko na-techran yan. Hindi na-techran yan. Ayoko mag-techran na yan. Okay. May I invite the speakers for the closing ceremonies to please sit on the center table, please. The speakers who will give their closing remarks. The 3 JSCC principals or on the right table. Ayaw lumipat? Oo. Dito may option po kayo. Asek, asan ka na Asek Miko? Okay, please lumapit ka na dito. Rafa and Christian, please sit close to the stage. Okay. Justice Singh, please. Okay ka na dyan. Meron pa po bang hindi tapos na workshop? If meron pa bang workshop, guys, let me know kung go na ako. Kompleto na ba ito? Pa-check na. Magandang hapon po sa ating lahat. Good afternoon, ladies and gentlemen. We have reached the conclusion of our 2-day National Decongestion Summit, a conference to unlock solutions to jail and prison overcrowding. Your attention, please, Your Honors. Thank you. 4 plenary sessions and 16 workshops. And the opening ceremonies to top all opening ceremonies with that gathering of the 3 branches of government, international development partners, civil society, the IBP. the sharing and presentation of knowledge, insights, and various perspectives across the issues relating to congestion in our jail and prison facilities now provide us with a rich source of ideas, guides, and information for us to take back to our respective agencies, institutions, and organizations. As we reach the conclusion of our summit, we will hear from each of the member agencies of the Justice Sector Coordinating Council, beginning with Assistant Secretary and Spokesperson of the Department of Justice, the Honorable Jose Dominic Clavano IV, member of the JSCC TWG on Communications and Partnership Building.
Honored guests, colleagues, and partners in reform, as we close the summit, let's reflect on the powerful directive, and to borrow some of the words from the Speaker of the House of Representatives, words are not enough, actions must follow. This sentiment resonating throughout the humorously crowded venue, emphasizing the very challenge we aim to surmount. In this ironically packed space, where we joked about needing a summit to decongest the summit itself, we've been vividly reminded that embodying change is integral to our mission. Even without the necessity for bunk beds or roll calls, our agenda was rich with substantive discourse, underlining the urgency of translating our dialogue into decisive action. Transitioning from this realization, our plenary sessions have been the cornerstones of this summit. They've set a collaborative tone, marked by contributions from esteemed figures including the President, the Senate President, the Chief Justice, the Speaker of the House, and other dignitaries. The JSCC and international partners from the European Union, Australia, and the UNODC provided global perspectives, enhancing our local strategies with a worldly view. A key highlight of our summit was addressing the challenges of jail decongestion and introducing the jail decongestion concept note. This signifies our commitment to a practical and enduring improvement in our justice system. We've initially focused on decreasing admissions by revising custodial hearing and bail rules, promoting fair justice access, especially for the less privileged. Our long-term goals emphasize legislative changes to improve prison management efficiency. We advocate for laws facilitating adult offender diversion and frameworks for their reintegration and psychosocial rehabilitation. These strategies aim to transform our penal system into one that honors individual dignity and rights, ultimately aiming to reduce recidivism and shift towards a more rehabilitative, less punitive justice approach. In the past 2 days, we engaged in insightful explorations and discussions that provided valuable insights into improving our criminal justice system. The participatory defense models of the USA and the Read Your Way Out project stood out as exemplary initiatives showcasing the transformative power of community engagement and the pivotal role of education and rehabilitation in the justice process. Sessions on digitalization and data management highlighted innovative tools for enhancing the efficiency and transparency of our system. Brazil's implementation of custodial hearings, significantly reducing pretrial detention rates, offered a compelling model for systemic change. The diverse strategies presented in the workshops, drawing from international reforms, such as Mexico's pretrial detention system overhaul, emphasized the importance of expediting legal proceedings and reducing case backlogs. These insights, coupled with an emphasis on input reduction for decongestion and efficient releases schemes and policies discussed in our concluding sessions, provide a comprehensive blueprint for refining and enhancing our justice system for better outcomes and more humane practices. In addition to all this, I would like to call attention to a particularly poignant part of our summit, hearing from the PDLs who shared their experiences. Their stories not only humanize the issues we are tackling, but also emphasized the profound impact of rehabilitation and reform. Listening to them, it became clear that the path to a fair and effective criminal justice system lies in reformation, not just incarceration. Their narratives underscored the importance of programs that support rehabilitation, education, and reintegration, aligning perfectly with the rehabilitative and less punitive approach we strive for in our own justice system. We, the DOJ, together with the JSCC and all our partners, are committed to actualizing the plans and proposals that have emerged from this summit. We stand ready to ensure the steps we take from here are not only meaningful, but act as a catalyst for real and lasting change. As we part ways, let us hold fast to the collaborative blueprint for action we've created. Let's continue to work together for a just, fair, and humane society. Thank you for your dedication, your insights, and your unwavering commitment to the cause. May we continue in our shared pursuit of justice and equity. Thank you very much.
Mahirap makulong. Mahaba ang isang oras. Magpakailanman ang isang taon. Mahigit 3 taon nang nakulong si Janjan sa Zamboanga City Jail Mill Dormitory bago ito muling makulong dahil sa kasong may kaugnayan sa ilegal na droga. Sa pagitan ng mga taon, ipinagpasalamat ni Janjan ng tulong ng Paralegal Service Unit ng pasilidad.
Ang hirap talaga sa loob, masikip, mainit, yung situation mo kung bago ka lang, lalo na natutulog kasi baba pa ng tarima. At yung first night ko dito, naalala ko talaga, natulog ako sa pinakadulo na malapit sa CR. Tapos malapit talaga sa CR na sobrang basa. Naalala ko, nagising ako around mga midnight yun. Natutulo na kasi may mga bagong ligo, mga ganung oras kasi may mga pila yan Hindi lang natulo yung tubig sa mukha ko, pati yung luha ko natulo na rin. Sasabi ko, sobrang hirap pala dito. So, ngayon, iba na talaga, di na tulad dati, hindi na ganun kasikip. Especially nung nagsimula na yung jail decongestion na project ng bagong warden namin ngayon. Nagsimula ito noong January.
Gaya ni Janjan, 26 na taon nang nakakulong si Anggo sa Zamboanga City Jail dahil sa 7 kaso ng kidnapping for ransom at serious illegal detention. Aminado siya bilang dating commander ng MNLF na hindi niya inasahan ang pagtagal ng pag-usad ng kanyang kaso, lalo at sa sarili niya, hindi niya ito ginawa. Bagamat mahigit 2 dekada nang nakakulong sa City Jail, hindi naman ito nawalan ng pag-asa, lalo pa at nakikita niya ngayon ang kasalukuyang decongestion program ng pasilidad.
Because of our persistent and relentless, yun talaga, sulat ng sulat, makulit sa korte until na napakinggan kami at saka na-reduce namin yung insular prisoner. And happy to say na ngayon, konti na lang yung insular prisoners namin.
Sa kasalukuyan, pang-37 na pinaka-congested sa buong bansa ang Zamboanga City Jail, habang ika-6 naman sa may pinakamataas na bilang ng mga nakakulong. Mabigat ang responsibilidad na pangalagaan ng mga PDL sa loob ng piitan. Batid din ng pamunuan ang nawawalang oportunidad sa mga ito sa matagal na pamamalagi nila sa loob. Kaya naman, sinisikap ng Zamboanga City Jail na mapabilis ang pagpoproseso ng kanilang mga dokumento habang mas aktibo sa pakikipag-ugnayan sa korte at iba pang mga ahensya ng gobyerno.
Yung release kasi natin, this time kasi, so mabilis na siya yung process unlike before. Kasi yung release natin, before kasi, pag na-verify natin sa OCC, so it will take siguro mga more than a week bago sila mag-reply. So, but this time, it only took 3 to 4 days. At saka meron din kami talagang everyday follow-up just in case after a day, hindi sila nagre-reply. So, kinukulit na namin sila. So, with that, nare-release namin sila kaagad. So, mas mabilis yung decongestion natin ng mga BDL.
Habang tinutugunan ang pagpapabilis sa proseso ng kaso ng mga PDL at upang tiyakin ang kanilang kahandaan habang dinidinig sa korte ang kanilang mga kaso, patuloy namang tinututukan ng pasilidad ang kanilang mga pangangailangan para sa konting pagkakakitaan at kahandaan upang tumanggap ng mga trabaho o magsimula ng maliit na negosyo sa kanilang paglaya. Tinututukan din ito ang edukasyon lalo na at may mga PDL na hindi pa marunong bumasa at sumulat. Mahalaga ang edukasyon upang tiyaking produktibo ang pamamalagi ng mga PDL sa pasilidad. Gayun din ang iba't ibang welfare and development programs upang tulungan sila na maihanda ang kanilang sarili sa kanilang paglaya. Bagamat maraming mga kakulangan sa kagamitan at sapat na pondo, sinisikap ng Zamboanga City Jail Male Dormitory na matulungan ang gaya ni Janjan at ang Go upang magpatuloy sila sa kanilang pagbabagong buhay. Mahalaga sa pamunuan ng Zamboanga City Jail na mapangalagaan ang mga nakapiit sa pasilidad nito habang itinataas ang antas ng pagkilala sa kanilang dignidad at karapatan bilang tao. Nilang man sila ng araw, buwan o taon sa piitan, dama na nila ngayon ang pag-abot ng kabutihan at katarungan sa kanila.
May I now call on the DILG Undersecretary for Public Safety and Co-Vice Chairperson of the National Decongestion Summit Steering Committee, the Honorable Undersecretary Serafin Barreto, Jr.
Thank you po. Ladies and gentlemen, esteemed participants and distinguished guests, a wonderful afternoon to all. Mapagpalayang hapon po sa inyo lahat. As we draw the curtains of this summit, I am expressing my deepest gratitude to all of you on behalf of the DILG Secretary Ben-Hur Abalus Jr., to our President, the heads of our legislative branch, the Supreme Court, the Department of Justice, especially to the Justice Sector Coordinating Council, or JSCC, to the European Union Justice Sector Reform Program under governance in Justice II, or dubbed GOJUST II, and the United Nations Office on Drugs and Crime, or UNODC, sirs, and the Australian government, and the European Union, also to the BJMP, the BuCor, sa Preso Foundation, na narito, sa IBP, and other members of the civil societies. Thank you very much sa inyo pong partisipasyon, tulong para sa tagumpay ng ating ginawang summit. To share with you relevant Bible verses related to humane treatment of prisoner in the book of Matthew 25:36, which says, "Naked, and ye clothed me. I was sick, and ye visited me. I was in prison, and ye came unto me. Naging hubad at inyo akong pinaramtan. Ako'y nagkasakit at inyo akong dinalaw. Ako'y nabilanggo at inyo akong pinaroonan." Yan po sinabi nating Panginoong Jesucristo. Sinabi rin niya, "Verily, I say unto you, inasmuch as ye have done into one of the least of these, my brothers, you have done it unto me." These statements from the Bible remind us our very purpose and responsibilities for humanity. For our fellow men who are deprived of their liberty in places of detention. To the summit session and workshops, we have covered legal remedies and innovative judicial strategies, community engagement models, digitalization, case processing and speedy disposition of criminal cases, clinical legal education, and resourceful initiatives and projects from various agencies, organizations, and established justice zones created in this country, among others. We also delve into the experiences of other countries. Thank you to the Brazil and United States government. Learning their best practices toward decongestion and criminal justice reform. In this summit, we also listen to testimonies of former persons deprived of liberty or PDLs and their experience inside the jails. Their narratives provided us with profound insights into the challenges faced within our correctional facilities. Also, from the awardee of the Outstanding Correctional Service Award by the ICPA, Jail Superintendent Xavier Solda, who strengthened the paralegal unit through his building capacity system in Zamboanga City Jail, and who make a quotation or statement of "do it and it can be done," na sana po yan din ang ating maging kaisipan upang magawa po natin lahat ang ating gustong mangyari sa ginawa nating sa dalawang araw na ito. Let me take this opportunity before finally conducting this activity, to express our gratitude to the judicial sector, particularly the Supreme Court, regarding the formulation of the writ of kalayaan, especially to Honorable Mario Victor Leonel. Napasaya po niya yung unang araw natin dahil sa kanyang paliwanag regarding the writ of kalayaan. And while this is pending approval, we would like to propose to the plenary the continuous implementation of the transfer of inmates from overcrowded or congested jails to a less congested facilities within the Metro Manila area. Na ginagawa naman po natin ito, kaya lang kuminsan may mga problema dahil kine-question yung legality. Pero nung marinig ko po itong writ of kalayaan, nalaman ko na hindi naman pala kailangan yung mga batas-batas dyan for registration. Kasi ano yan, nasa ating korte ang ano dyan, ang laro. This can be a practical solution to address the immediate issue of jail congestion. Kasi kung titingnan po natin talaga, hindi naman po lahat ng jail dito sa Pilipinas o kahit sa Metro Manila ay congested. Meron pa po tayong mga jail dito sa Metro Manila na maluluwag. Mga negative pa nga po, negative 55%, mga ganyan. So ibig sabihin po, kung i-manage lang po natin ang distribution ng mga PDL natin, kung saan natin sila patitirahin, ay luluag pa rin po ang ating mga kulungan. So, by redistributing inmates across different facilities, it can help alleviate overcrowding and improve living conditions for inmates. Sana po, ang gawin na lang ating sistema sa pagkukomit po ng ating PDL ay direkta po sa BJMP. Hindi po yung dating ginagawa na kinukomit natin sa warden ng isang facility. Kung magagawa po sana na committed to the chief BJMP, so ang chief BJMP po ang mag-decide kung saang maluag na jail niya ilalagay. Within Metro Manila, din naman yun. At madali lang ang kanilang transportation kung sakaling may mga hearings. In addition to inmate transfer, the institutionalization of the electronic court hearing system na ginagawa na po natin itong pandemic time can greatly contribute to address the problem of jail congestion. Electronic court hearings, also known as a virtual or remote hearing, utilized to conduct court proceedings. May this summit leave us with renewed sense of purpose and collaboration to continue improving the quality of life of our fellow Filipinos, including PDL. Thank you all for your dedication in sharing your expertise. Let us create a passionate system of justice, not a criminal justice system. See you next year to the Phase 2 of the National Decongestion Summit. Mabuhay ang bagong Pilipinas.
Thank you very much, ASEC Clavano and USEC Barreto, our partners in the JSCC. And now, for the judiciary, we will hear from the Vice Chairperson of the JSCC, TWG andyan ka na, on processes and capacity building, and member of the National Decongestion Summit Steering Committee, Court of Appeals Justice, the Honorable Jaime Fortunato Caringal.
Good afternoon, everyone. As I am one of the last speakers of this summit, I promise to make this very short and succinct. Over the course of the past 2 days, we did as the Chief Justice had asked us to do. We rolled up our sleeves and worked. Allow me, therefore, to give you some key takeaways which I have observed over the course of the summit. First, we all recognize that there is a problem. We would not have this summit if not for the recognition of the fact that jail congestion is a critical issue that plagues our criminal justice system. This is not just a matter of logistics or space. It is a profound reflection of the need to further improve the state of our justice system. Second, we have also noted that the problem has constitutional underpinnings. We have heard Senior Associate Justice Leonen, Justice Alameda, and Judge Matos speak specifically about this point. Judge Matos has relayed to us the Brazilian experience and how their Supreme Court has branded their own congestion problem as an unconstitutional state of affairs, a point to which Senior Associate Justice Leonen has offered his own novel solution, the proposal to adopt a writ of kalayaan. After all, congestion is a challenge to our commitment to human rights and dignity. We must always bear in mind that the congestion figures quoted so often during the course of this summit is not just a number. Rather, it represents thousands of actual lives who endure the conditions of our jails and prisons. Third, all of us here today, the judiciary, the executive through the DOJ, DILG, and their attached agencies, as well, of course, as civil society, are each in our own ways addressing the problem by providing solutions within our respective spheres of influence. We have heard the solutions provided by the DOJ through Yusek Vasquez, Yusek Andres, Director General Katapang, to reduce input and increase output. We have also heard from the DILG through the BJMP's Director Rivera, Senior Superintendent Valenzuela, among others, talk about their own projects, specifically the Read Your Way Out of project, digitalization, and other decongestion programs. We also listened to members of the judiciary talk about their own efforts through the justice zones, case processing, and speedy dispositions of cases, as well as interesting discussions on women PDLs and decongestion efforts in the context of Sharia law. Our CSOs, of course, also had a lot to share about how they help monitor and support the release of PDLs from incarceration. Finally, we learned much from our foreign speakers, all of whom have shared the best practices from their own countries, and which leaves us today with food for thought on how we could apply those initiatives here. Of particular interest, as relayed by Judge Matos and of course Judge Osorio, is the conduct of custodial hearings and pretrial detention reforms as a successful effort to decongest jails and prisons. While we recognize all these efforts I have just mentioned, we must also be aware that taken alone, these efforts will not be as effective. Which brings me to the last point. A long-lasting and sustained solution to jail congestion can only be had through a whole-of-government plus civil society approach. It is only through the concerted action of the government, of the government agencies overseeing the criminal justice system, in partnership, of course, with civil society, that the plague of jail congestion may be sufficiently addressed. That is why the Justice Sector Coordinating Council is an important institution of government, because all efforts to decongest our jail and prison facilities may be discussed at that level and implemented at the agency level. As I close, allow me to emphasize that addressing the issue of jail congestion requires a multifaceted approach that involves judicial reform, infrastructure development, and policy changes both at the administrative and legislative levels, all aimed at addressing input, throughput, and output issues to congestion. Let us work together to ensure that our jails and prisons serve their intended purpose, not as places of inhuman punishment, but as institutions of justice and rehabilitation. The work certainly does not end today. It continues until we have achieved our goals. Thank you and safe travels back home.
Maraming salamat po, Justice Caringal. We will now hear the concluding words from our development partners. From the European Union Governance and Justice Program, or GOJUST, we have Mr. Christian Eldon, team leader of the GOJUST II program.
Justice Singh, thank you for taking the lead in organizing this summit. And to the members of the steering committee responsible for organizing the summit, thank you for your dedication and commitment. To Attorney Laura Del Rosario, thank you for being our host. And to your team at PMO, thank you for ensuring that all details and all protocol issues were properly addressed. That was a relief for many reasons. On behalf of GOJUST and the EU, it really gives me great privilege and honor to have been involved in supporting and organizing this summit, the first ever jail decongestion summit in the country. And jail decongestion is really something that cuts across everything GOJUST does. We support coordination, both nationally and at the justice zone level, and we have seen input from our justice zones on activities that initiatives they undertake to reduce jail congestion. Jail decongestion is actually one of 5 thematic areas that the justice zones are working to address. We support automation, automation to facilitate information sharing, collection, generation, and analysis. And we have seen how important that is also to also contribute towards jail decongestion. We have seen the issue of the transparency boards, how important that is, the information it provides. We support civil society through our grants making mechanism, and we have also seen examples in the various workshops of support to the clinical legal education programs of the universities and the role that the law student practitioners can play also in reducing jail decongestion. Finally, we support evidence-based research to inform policy making. And it was as part of that latter support that the jail decongestion study was commissioned. This study was presented by you, Justice Singh, to the Justice Sector Coordinating Council in February of this year. It was well received. It was adopted by the JSCC, and it was decided that the JSCC would, on the basis of that, organize this event that we have been here to witness over the last few days. And I think that's very important, as previous speakers have mentioned, and I think we have all noticed throughout the event, that this issue of a whole government approach is critical. And without it, you cannot address jail decongestion. And this is why it's so important that it's been organized under the JSCC. It has ensured that very thing, the whole government approach. We have heard reference to the 3 C's several times: communication, cooperation, coordination. In the study, jail decongestion study, you refer to the process of input, throughput, and output as critical elements to facilitate jail decongestion. And that suggests a sort of pipeline, justice pipeline approach with with something coming in one end and going out the other end. And we know from other countries where coordination is also important for the justice sector, that they use illustrations such as the river of justice, illustrating that the river, if you pollute it at source, you pollute it all the way downstream, all the way to the mouth of the river. The illustration of the chain, with the chain not being stronger than its weakest link. We all have to move together in the same pace. Otherwise, we will not achieve the objective. Also in relation to prison decongestion. In the JSCC, we have two branches of government normally represented. We have the executive and we have the judicial. An important observation, and I think something that we also noticed in this summit, has been the importance of the legislative branch of government as well. We heard from the Speaker of the House that they are thinking about introducing 6 major reforms, actually, again, mentioned in the jail decongestion study. So we have, I think we can say we have the legislative branch of government on board with us as well on this. There's one other thing that I always cannot help but notice or observe when we talk about jails, and that is the human factor. If you think about it, all the other agencies talk about cases. It's only the jails that talk about people, persons, PDLs. We have seen the testimonies and we have seen videos where we see the terrible conditions that the PDLs are living under. And I think that's a good thing to be reminded about when we talk about jail decongestion. It brings in another factor, another focus. And I think with all these elements together, the fact that we have the JSCC so dedicated with the 2 branches of government, we have the legislative branch of government coming on board, and we have that focus on the human factor as well, it encourages me to come with a bold suggestion. Could you imagine that the JSCC would propose as a policy to introduce a ceiling on the number of PDLs that you would accept in this country? If you think about it, it might be, as I say, a bold suggestion, something that is wild, going too far. But if you think about it, it is really an objective, a goal that can bring the whole justice sector together. Everybody would have to be involved, including the legislative branch, to ensure that laws are adjusted, to ensure that that ceiling is not breached. We did it in my country. Back in the 70s, decided that the ceiling would be what was at that time the level of PDLs, and that has remained the number since then. And we have introduced laws, policies, and everything to make sure that that has stood still since then. You will need to involve the media, civil society as well, in addition to what you have already with this JSCC and the legislative branch. I think that brings me to think about the way forward. My understanding is that all the findings, recommendations from these 2 days will now be reviewed and analyzed, and they would feed into the action plan that, again, Justice Singh presented yesterday. So we know that there's already an action plan in place to implement many of the suggestions. So they will just feed into that and strengthen that even further. The JSCC, we have heard, will monitor the implementation of that action plan, and we will hear from time to time, every quarter or so, about the status of implementation. That also augurs well for an effective action plan being implemented. And then we have a next event scheduled for February or March next year, where again, I think we will be able to revisit some of these recommendations, see where we are in terms of implementation. And we will also be able to look, I think, more long-term on the way forward. So with that, I thank you all for 2, I think, very pleasant and very active and very important days that I think can take us a long way forward to address the problem we are all looking to really do something about, reducing prison congestion in this country. Thank you so much.
Thank you, Christian.
We now call on Mr. Rafael Barreto Sauza, the Crime Prevention and Criminal Justice Officer of the United Nations Office on Drugs and Crime, or UNODC.
Magandang hapon sa iyon lahat. It is truly a pleasure to be at this final ceremony with such illustrious people. I'd like to take the same stance and start with some thank yous. Starting with the Supreme Court, which under the work of Justice Singh and under the leadership of Chief Justice Gizmundo, has been really a guiding light in thinking about criminal justice reform in the country. But it wouldn't be complete if they were not part of the Justice Sector Coordinating Council in this wider approach. I'd like to thank, of course, the other principals of JSCC, the Department of Justice, the Department of Interior, local government, and the bureaus under both. Also like to thank the Commission on Human Rights, who have been part of this discussion early on, integral part of this meeting, of this event. I'd like to thank GOJUST II for the partnership and for allowing us to join forces in achieving what has been achieved here and potentially a new one. I'd like to thank Australia and the European Union for the generous funding. I'd like to thank the jail officers and the judges and the prosecutors and the public defenders and the corrections officers who are the front line. And then again, making reference to Justice Singh, who said from day one, the first time we met, this is not about only the high level, this is about the front lines. If we do not see what it's like every day on the front lines, the high level decisions won't be properly made. And how right was she? This is the result of all of that, bringing the bottom and the up together and finding a nice middle, I would say. But I'm also inspired by Attorney Laura, who said in the opening that there was a lot of touching in the heads, but in the end, there was some touching in the heart with the PDL who spoke. So inspired by that, I think nothing better to touch the heart than perhaps some art. So I want to quote a US singer called Nina Simone. And it goes like this: I ain't got no home, I ain't got no shoes, I ain't got no money, I ain't got no class, I ain't got no sweaters, I ain't got no faith, I ain't got no mind, I ain't got no mother, I ain't got no culture, I ain't got no friends, I ain't got no schooling, I ain't got no love, I ain't got no name, I ain't got no God. Then what have I got? Why am I alive anyway? Yeah, what I've got, no one can take away. I've got my hair, I've got my head, I've got my brains, I've got my ears, I've got my eyes, I've got my nose, I've got my mouth, I've got my smile, I've got my chin, I've got my neck, I've got my heart, I've got my soul. I've got life. I've got my freedom, I've got my life, and that I'm going to keep. I wanted to realize that because in the absence of so much, there is humanity. And I think that why we're here is to celebrate that, to celebrate humanity and realize that even at these conditions, we've seen such bad things, no, that happen in detention, the conditions, the experiences that were shared. And the way that this was addressed here is through a comprehensive approach. And this was represented for us in three ways. The first was mentioned very well. It's an all-of-government approach, so comprehensive in that sense, on the institutional way. The executive branch, the legislative branch, the judicial branch, but also institutions in the civil society. The second point of comprehensiveness came from the participation. And I want to highlight here the participation of persons who are directly affected by the system. First, the formerly incarcerated persons who shared with us their experience. And that brought us closer to our hearts in thinking about this. Not just thinking, but also feeling perhaps the problem. It also affected directly the persons deprived of liberty, who in over 180 submissions through that, from the logos, and all the jail officers, all these people in many parts of the country who knew about this, who got excited about it, who incentivized PDLs to draw and to make art, they were also part of this. Even the bags that you carried, and the prospect that might generate good contact time allowance. There is nothing more interesting to think that you are working and being creative towards thinking about decongestion or thinking about your freedom, and that can actually facilitate your freedom in its purest way. By doing so, getting time allowance. And the last part of comprehensiveness, which I think is very important, is the interdisciplinarity. Throughout these days, this was not a legal conference. It was not only about the law. It was about art, it was mentioned. It was about the logos and all these different ideas. It was about technology and digitalization. It was about science and evidence and what are we basing our decisions on and the data. It was about integrating all that in thinking solutions. So my final quote or my final appeal would be to quote Andres Bonifacio, which is someone I've learned to read a little about, and I know it's one of the greatest personalities in the country. And I quote, "Let us not be passive as spectators, but active participants in shaping the future of our country, of the Philippines." And I think that when you think about decongestion as a prospect, it seems so far away, And it was interesting to see Judge Eduardo, mention the show, actually, the prison where Nelson Mandela stayed. And I'd like to end with that quote. Nelson Mandela, he said, "It only seems impossible until it's done." It's the first step into doing it. Maraming salamat po.
Maraming salamat, Rafa. And with that quote from Nina Simone, Andres Bonifacio, our summit has officially closed. Palakpakan po natin our steering committee of the National Decongestion Summit led by Justice Singh and dito po sa mesang ito, the Court of Appeals and Sandigan Bayan Justices. Thank you so much for leading us. Mabuhay po kayo, Judge Bernard Bernal also. To the Secretariat, to the PIO, maraming salamat po sa likod ng rehas, panibagong bukas. Bukas po ay long weekend. Salamat po, everyone, and mabuhay!